This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about a corollary to insurance fraud, where the permanent punishment for conviction of having 1 ounce of cocaine turned out to be a governmental overreach and abuse of power by an administrative agency that required it to be reversed. And after recovery from cocaine abuse, Dr. Stephen White regained his license to practice medicine and found that CMS refused to allow him to bill Medicare for his services because of a single conviction for cocaine possession. Dr. White challenged 2 unfavorable decisions made by the Secretary of the United States Department of Health and Human Services, the Secretary, that denied and revoked his Medicare enrollment. The decisions rendered by the Appellate Division of the Departmental Appeals Board were based on Dr. White's 2010 guilty plea and deferred prosecution for possession of less than 1 gram of cocaine, which occurred in Texas in 2007. In a case entitled Stephen White, M.D. versus Xavier Becerra, the Secretary, on October 28, 2024, the United States District Court for the Eastern District of Washington applied justice and entered a judgment reversing the decision of the Secretary. He did so in a motion for summary judgment, which the court found to be appropriate if the moving party showed that there was no genuine dispute as to any material fact. Dr. White is an orthopedic surgeon. In 2006 and 2007, he was arrested and charged with possession of cocaine in Texas. He was able to rehab and become clean of his problem with the drug. The Texas Medical Board that revoked his license when he was arrested then monitored his recovery and compliance and allowed him to practice again. Dr. White had no violations for 9 years following his arrest. He is currently practicing medicine in Washington State and is an enrolled Medicare supplier. The administrative law judge sustained the denial of his Medicare funding, finding that CMS had a legitimate basis because Dr. White was convicted of a felony offense. The board affirmed the ALJ's decision, and Dr. White appealed that decision to the United States District Court. Now, the Medicare program provides health insurance benefits to people 65 years old or older, like me, and to eligible disabled persons. Suppliers such as Dr. White must be enrolled in the Medicare program and be granted billing privileges to be eligible to receive payment for care and services to a Medicare-eligible beneficiary. CMS, the administrative agency for Medicare, may deny a supplier's enrollment for any reason stated in federal statutes that allows that CMS may deny the provider's supplier's enrollment in the Medicare program for some of the following reasons, basically felonies such as insurance fraud and similar crimes. The ALJ found CMS had a legitimate basis because White was convicted of a felony offense that CMS determined to be detrimental to the best interests of the Medicare program and its beneficiaries. but he had been free and clear of the problem for 9 years. Dr. White presented equitable arguments to the ALJ that, one, he had self-reported and was not practicing when he did so. 2, using his self-report to deny would encourage other physicians to not self-report. 3, he has fully complied with the terms of the modified license. And 4, eventually, he was allowed to practice medicine without limitation. The board, regardless, affirmed the ALJ's decision upholding CMS's denial of Dr. White's Medicare enrollment and rejected Dr. White's argument that the timing of the revocation action by CMS was clearly retaliatory and intended to apply pressure on Dr. White for additional monetary penalties. The USDC, analyzing the issues, found that CMS's decision to deny Dr. White enrollment in Medicare and revoke his privileges and the subsequent board's affirmation were arbitrary and capricious and not supported by substantial evidence. CMS did not have a legitimate reason to deny enrollment or revoke his license to bill Medicare because the record did not support the assertions of CMS that Dr. White's 2010 conviction for simple possession of a small amount of cocaine was detrimental to the best interest of the Medicare program and its beneficiaries. The United States District Court, therefore, understood that although deference is owed to administrative agencies as they adjudicate numerous complex cases before them, the court may not simply act as a rubber stamp for agency decisions. And because CMS failed to provide a reasonable basis for denying Dr. White his enrollment in Medicare or revoking his Medicare privileges, the decision of the Secretary was reversed. In my opinion, a doctor should never get involved in or addicted to illegal substances like cocaine. The fact that a doctor self-reported his involvement with the drug, became rehabilitated, was clean and proper for 9 years, and practices medicine legally with a valid license does not appear to pose a danger to Medicare as to those doctors who are arrested every year for fraudulently sending billings to Medicare. And if you look at my newsletters, Alma's Insurance Fraud Letter, you will see dozens of convictions for that kind of abuse of Medicare, and none for illegal drug use by the doctor. The decision of Becerra, the ALJ, and the board was clearly retaliatory and abusive, and the USDC had no choice but to reverse the board and let the doctor continue to practice medicine and charge Medicare for his services. Overreach by the administrative agency was stopped by the court properly. And as the United States Supreme Court has recently stated, a court does not have to rubber stamp administrative agencies. A court is not obligated to follow what the administrative agency does. This video was adapted from my blog, Alma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. You'll also gain access to the more than 4,900 blog postings. Please tell your friends and colleagues about the blog and these videos so that they too can subscribe. They're free. And if you watch on YouTube or on Rumble, please click on the like button for YouTube or the thumbs up button for Rumble. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication.